So Ilona and I are going to bring up situations and you're going to tell us if it's a red flag or a green flag and why.
Okay. We should have a beige flag, maybe. Beige.
So the first one is if a partner says, I want full custody on day one.
That's a red flag.
Welcome back to the Glamorous Grind. We're kicking off season 2 with a powerful episode about the hidden costs of family law. Not just the financial ones, but the emotional toll, the custody battles, and what happens when Child Welfare Services, now known as Child and Family Wellbeing, steps into your life.
We're joined by an incredible guest who's been in the trenches with high conflict cases and knows how to fight smart.
Attorney Nicholas Moore.
Thanks for having me.
Tell us about your experience with juvenile court.
So when a case gets filed against a parent, or really a case is filed concerning the welfare of a child, the parents, both of them are entitled to counsel.
So that our viewers understand, there's family court and then there's juvenile court. The types of cases that end up in juvenile court is where one or both parents may be losing custody and the child may potentially become the ward of the court. And in family court, it's different. Anyone who has a paternity case, a divorce case, or arguing over their children without there being any concerns about their safety necessarily can go to family court and open up a petition.
Domestic violence or drugs are generally the two big types of cases that end up in juvenile court.
What percentage of cases that you've dealt with, you would say, dealt with physical abuse versus emotional? Although obviously if there's physical abuse, emotional abuse is part of it.
For the most part, domestic violence cases involve some serious allegations of physical violence that occur in front of the child.
And there are occasionally child abuse cases as well that deal with the physical violence to the child.
The way that a case gets reported to Child Welfare Services is either someone calls in and makes a report that's often anonymous, or it would be a mandatory reporter who is a doctor, a therapist, a teacher. There are a number of mandatory reporters that if they hear about any sort of abuse, they have to report it to Child Welfare Services. Now, let's go back to how things end up from family court and juvenile. So either for the parties who were never in family court before and there was an incident, or it was in family court already and something happens and Child Welfare Services gets involved and then they take action, file a petition in juvenile court, and at that point, any family law or custody proceeding that's pending in family court is pretty much on hold until things are resolved in juvenile court.
A particularly memorable one involves restraining orders that just keep getting dismissed at the temporary restraining order stage, and then new allegations of violence or abuse are made. And at that point, the government is essentially considering the parent non-protective or codependent. They say, here's our documented history of violence. We have this from the family court file. Here's a new allegation that was raised in a new temporary restraining order. We know that this has happened before on multiple occasions. The child is at risk. We don't believe that this person is going to follow through with this restraining order, and so they'll remove the case from family court to juvenile court.
Those processes are in place to assist with maybe spouses or partners who are not strong enough to walk away on their own. Kind of forces their hand.
That's a good way to describe it.
The average victim of domestic violence, it takes them 7 attempts to leave. And that's not 7 plans. That's not 7 times that they've written out, their goals in terms of leaving or thought about it. It's 7 actual attempts to leave their abuser. And if that's on average, then there are a lot of people who are significantly above that average.
What is your advice to victims of domestic violence who haven't yet separated themselves from the idea of saving their family and may not be putting their child first and may end up in the system?
I'm constantly trying to figure out the right combination of words to express the urgency of the situation and my sincere desire to put them into a place of safety so they don't have to worry about the legal consequences of it. And I think it's a real case-by-case and personal basis where it's a struggle to explain to people because you are essentially trying to get a person to conceptualize the death of an idea, right? Which is the idea that I'm going to raise this child with somebody else. We're going to be a family together, right? And if they're not willing to accept that, not only is it a distinct possibility that that may not happen, but there will be severe consequences unless they take immediate action, it's a really hard thing for a person to process.
What are different types of cases that are dealt with in juvenile court?
Sure. The most common is drug and alcohol dependency. That's where at least one parent has a serious addiction issue that requires the child to be removed because the drug use has placed the child at risk, either of exposure or there has been some positive exposure to the child, or it results in the child being placed in dangerous situations.
What does exposure mean? Does that just mean they're around the parent when they're on drugs or alcohol?
Testing positive for drugs or
The child?
yes.
Wow. So what about, because drugs could be illegal, but alcohol is obviously legal. At what point would alcohol abuse be considered enough to move into the juvenile court system? Like if, for example, a parent is an alcoholic, but there's no physical abuse, there's no physical violence, just gets drunk. Is that enough?
Yeah, it is enough. And there's not a bright line. So there's no particular line that can be crossed with alcohol that puts you in juvenile court. The heuristic is essentially your alcohol use creating unsafe situations for a child. So we'll see it in DUI cases where there's a child in the car. You'll see it in certain cases where alcohol is contributing to other types of unsafe behavior. And that can look like parent day drinking and falling asleep, right? While they're supposed to be at home watching the child, and the child or children are spending several hours sort of unsupervised, passed out on the couch. By the time a case reaches juvenile court, the court is slowing everything down and saying that everything's going to be analyzed, and there's a process for that. So juvenile court has dependency and delinquency. Dependency is when there's a health and safety risk identified for a child. Delinquency is when the child has committed a crime. The adage is that everything a child says in juvenile delinquency is not believed, but everything a child says in juvenile dependency is believed.
And that's so hard because kids, their imaginations run wild. You have 3.
And they can be coached. One of the things that the family court services mediators look for when they interview the children, if they do that in any specific case, is whether the child is coached. And the way that parents often coach a child is by telling them what to say, by preparing them in advance, by scaring them they're not going to see them, or bad mouthing the other parent. They understand what answers you probably want to hear, and they're going to tell you what you want to hear. No? How often has that come up in juvenile court where the evidence elicited by one parent against the other through video of the child been used?
It's a great question because, well, first, the dynamic is not really one parent against the other. It's really the state against both of the parents at the time that it reaches the juvenile court. So the court is really less concerned with what one particular parent thinks is the right idea as opposed to just holistically what is the right approach for the situation.
So Nick, coming from a different background that's not in family law, this is all very interesting to me. How did you get started in this field?
By accident.
Tell us about that.
I wasn't really sure what type of law I wanted to practice coming out of law school. I was really interested in white-collar criminal defense. And I was fortunate to have an opportunity where a great criminal defense attorney was a mentor to me, brought me along for several big trials at the very beginning of my career, helped me establish my own practice by referring me cases. But I knew that I needed to find other ways to get into a courtroom. And so domestic violence restraining orders really were that kind of first opportunity to litigate something that's very similar to the criminal realm, albeit in family court. And I was fortunate enough that when I was first starting out, I needed some office space, and there was an opportunity to be co-located with a victims advocacy organization who said, we'll give you a great deal on office space if you're willing to do pro bono hours to help domestic violence victims. And so the opportunity presented itself, and I just sort of started doing it. And looking back, sort of more than a decade later, it's what I'll be doing for the rest.
Yeah, you seem very passionate about it. And we've had a few consults together on DV victims, where we kind of combine the family law perspective and the personal injury side of DV, and you're very good with clients. You're a great communicator. You have incredible empathy. So how did that happen? Like, what's your background?
Yeah, I think the reason I stuck with it as opposed to like looking for a different area of law was that there's real tangible success when you're doing domestic violence cases. And that success is generally you have a victim that is afraid that their story isn't going to be told well, that their voice isn't going to be heard, that their concerns aren't valid. All of these things, right, are in the mind of a person who's wondering, like, should I even go forward with this? One of my favorite closings to give in a domestic violence case is that at the end of the day, right, victims know that some lawyer is going to stand up in a courtroom, right, and with a smile on their face say, victims don't do that. Victims don't do that. Victims don't do that. And it's a really important, I think, argument for everyone to hear, which is that a lot of lawyers are hardwired to think that way. And if you know that that's going to be their approach to the case, well, then, you just got to help them tell their story in a way that makes them feel confident that they're being heard. Because judges aren't going to believe that, well, victims don't do that. Because we know there's no such thing as a perfect victim.
Right.
And I think we're finally at a place in society where we understand that victims don't behave rationally. Right? That's there's no right way to respond to a safety concern. We all think we know what we would do in the moment. The truth is, when faced with those moments, most people freeze or flee.
Here.
But occasionally you get a victim that fights back. And the other person will say, well, that's the abuser right there. Do you see the scratches, on this person's arm? Well, of course there are scratches on this person's arm.
Yeah.
They were strangling, right? Then what are you going to do when you're going to claw back, right? If you have somebody laying hands on you. And so, a lot of people are sort of locked in this mindset of, well, victims don't do that.
Yeah.
And if there's one important message for anyone who's a victim to hear is your reaction to the abuse isn't relevant, okay? And if they want to make it relevant, then they're arguing the case the wrong way. All right, what's important is whether or not something happened.
And I think a lot of times, especially in, cases with children, when there's domestic violence, what people fail to take into account is, it's very easy to judge someone for staying with their abuser, right? Oh, how could you? But I think a lot of people I've seen, I've met and spoken with at least, thought that they were doing the best thing for their child. Oh, I don't want to get police involved. I don't want to make their dad out to be this terrible guy and arrested and make a big deal out of this. Like, it's probably okay. And, for someone like you or I, who are third party, we see this and we're like, oh my God, how could you have stayed? But for them, that was their life. And it wasn't anything crazy. It was hard for them to see beyond that. So I think just important to keep that in mind.
That's a really important perspective, right? Because it gets at everything is fear-based, right? If I leave this person and become a single parent, statistics say my child is going to have a worse outcome, right? If I leave this person and we're in a lower socioeconomic status because of it, statistics say my child is going to have a worse outcome.
Depending what statistics they read, because that's also arguable.
Yes, of course. But I think generally speaking, right, what we understand is that, children of single parent households will I think by and large have lower educational outcomes, lower socioeconomic outcomes. We don't fit neatly in the boxes for our lives, right?
I think statistics show that domestic violence causes severe damage to the emotional well-being of the children, their confidence level, their success in the future is impacted. Everything is impacted. And I think it's worse than just being raised by one parent who can provide you a stable, happy home. That's better for the child if they can live in a calm environment that's happy, even if they have limited visitation with other parent, versus living in a house where the parents are fighting, arguing in front of them, screaming, hurting each other. That will mess you up for life.
This goes to Mila's point, though, where that's the mindset of the person. It's like, well, I'm afraid that life will be more difficult this way because this happens rarely, right? This only happens when he drinks, or this only happens when someone. So it's intermittent, right? It's not a daily thing. But you're absolutely right that it's much better for a kid to grow up in a home free of violence, because one of the things that we know is that people who perpetrate the violence grew up in a home with violence, right? So that child that you're raising in a violent home is going to grow up to be a violent child.
The reality is you never deserve for someone else to put your hands on you or your child. And if it happened once, it will happen again. I've seen that in family law. I've seen that happen to me once in personal life, and I ended my marriage after 4 months because of that, because I knew that if it happened once, if it happened twice, it is going to happen again, because it happens to women, it happens to men, and to then have a family with someone or continue on is inviting more problems into your life, inviting court disputes in family court or juvenile court in the future. So if you can get out of an abusive relationship early on, when you see red flags, do it.
But when people are in that situation, they don't see that. I think especially a lot of times if, there's a codependency, whether it's financial or otherwise, someone can't even fathom their life without this other person who they depend on. And that's why I think it's a good time to talk about really quickly that there are services available for people, women or men, who don't have money, don't have jobs, and are being abused. And we actually are collaborating with currently One Safe Place, or the North County Justice Center, which is a center where women, men, kids, elderly can come in when they're abused and receive, treatment for free. Not only do they can get the restraining orders, they can get therapy, children can be seen, they can get medical services. I mean, it's crazy the services that are available for free to help in those particular situations where people don't have the funds or the finances, or they're dependent on a person who's abusing them.
Absolutely. Really proud of our firm's collaboration with One Safe Place. It's really exciting. The idea is that before places like the Family Justice Center existed, and this goes back to about 2002 when the Downtown Family Justice Center was first started, if a victim wanted to make use of county services, they would have to travel all around the county, right? And if they didn't have a car, by public transit, it could be a 2 or 3 day affair to get to all the different service providers. They have to retell their story at each provider. And so the idea was started back in 2002, 2003 by Casey Gwynn when he was the city attorney here, that we ought to create just a one-stop shop for people to tell their story one time and receive all the services they need.
Okay, so let's play red flag, green flag. So Ilona and I are going to bring up situations, and you're going to tell us if it's a red flag or a green flag and why.
Okay, we should have a beige flag, maybe. Beige.
So the first one is if a partner says, I want full custody on day one.
That's a red flag.
Why is it a red flag?
Well, the law in California says that it's in children's best interest to have frequent, continuous contact with both parents. And so the family court and even the juvenile court is going to create paths, right, for both parents to be involved in a child's life. All right. And so full custody, people have this idea in their mind that it means that this other parent doesn't get the opportunity to be involved at all. And if that's their mindset going in, then some reframing needs to happen in order to properly set their expectations.
How would you recommend that someone acts if their partner says, I want full custody on day one of the announcement of the divorce?
Well, I try and explain to them what the law says and what the law is going to do, which is going to give their partner a path or an opportunity, all right, to be an active parent in the child's life.
I think a lot of times people say that they don't really understand what it means.
Yeah.
I think they'll say, I want full custody, but they actually want the other parent to see their children just on a specific schedule. And they don't know that doesn't mean they're getting full custody. They're going to have primary custody, and the other parent will have the rights of visitation.
It does indicate a desire for control over the situation.
Yeah.
All right.
I think I don't practice in family law, but I've seen a lot of times where people will use custody as a weapon against the other spouse or ex-spouse or parent, and they'll say that just to hurt the other person.
Absolutely. Sometimes they'll be open about that desire, and sometimes it might be borne out by the other.
What about going to child welfare services interview when they knock on your door and leave a business card without legal counsel?
Huge red flag.
Why?
anytime you're dealing with the government, they're going to tell you things such as, we just need to hear your side of the story. Give us your version so we can write it up in favor of you and be done with it. Because I just need to talk to you and then write this down and it'll be okay. And the reality is that everything you say, they'll find a way to use against you if they feel like there's a risk to the child. Even if that risk seems very minimal, right? You'll see this with police. You'll see this with child welfare services. Talk to an attorney first, but understand that you're under no obligation to talk to them.
I would assume it's extremely emotional. And when you're emotional, you're not rational. That's inevitable. You could be giving a statement because it's innate, I think, to want to tell your side of the story and want to, tell everyone you didn't do anything wrong. And very important to take a step back and remember that even with the best intentions, you could accidentally misstate something that later will be used to, make you out to be a liar.
I mean, you could be asked by a child welfare service worker, do you ever drink? Don't lie about that. If you ever drink, even socially, say yes, because the moment you say no, most likely they're going to doubt the rest of what you said. But if you're asked, did you drink on any specific occasion, then that's a different question.
Red flag or green flag, keeping a shared bank account open during separation.
Oh, that's a red flag.
Why?
Well, because something is going to happen that's going to cause some problems with this account. All right, at some point in the future, somebody's going to make some expenditure that becomes the source of some degree of conflict. The sooner you can, I think, clearly account for what could be community or separate property from the outset of the case and have some clear boundaries, limits the disagreements that will happen in the future.
So California is a community property state, which means that everything both parties earn during the marriage is community property, equal, for both parties. But once you separate, does the community property separate?
Yeah.
Immediately? Do you have to file anything?
The property itself doesn't separate, but the idea that the property earned during the time period after separation is that it now becomes separate property.
Acquisition rule. If something was acquired during the marriage or while the parties are together, then it's presumed to be community property. If it's acquired after date of separation, then it's presumed to be separate property, but it's just a presumption. Presumption can be overcome by evidence that's presented. During period of separation, you purchase something, although it is presumed to be separate property. If you use community money from joint account to purchase it, then you'll probably overcome the presumption that it's separate property.
So is the date of separation a date when something is filed or submitted, or is it just when you decide that you're being separated?
It depends. I mean, it is looked at in terms of objective factors, but sometimes the parties will disagree as to when the separation happened. Living together can be messy, especially with somebody that you love and you built a life with, and there might be brief periods of love or romance, right, that could then be used to argue, we weren't separated. This was a reconciliation that happened.
There has to be mutual meeting of the minds, and it's clear to both parties that the marriage is over. So if you want to be sure that your finances are separate, you send a text message about it. You then don't text about how you love each other and you may get back together. There has to be clear, definite, hey, it's over. And if you're continuing to live together for financial reasons, then if arguing over date of separation in family court later, questions you'll be asked by the attorneys in deposition or trial will be, were you having sex still together? And one may say, yeah, we still slept together and I have pictures or I have photos or we slept on Christmas or whatever may have happened. That's relevant. Have you been going to conjoined therapy together, try to save the relationship? If you have a text message, it's over, but you're going to conjoined therapy or tried therapy to save the relationship, then you're not separated. That'll be strong evidence against your date of separation.
When should you open a separate bank account and close a joint account?
I think when you are fearful that the end really is here is probably the best time to do it. Like if you have that fear that it might be over, that's probably the time to start taking.
And it'll definitely be over.
So what's a process once the parties end up in juvenile court?
So the first hearing is an arraignment or a detention hearing. Right? And arraignment's just the fancy word for your first appearance in court where you're answering an allegation made by the government. Is there enough to kind of kick off this case, to make some temporary orders in the next 3 weeks? Because another hearing will be set within 3 weeks of that detention.
And at that hearing, they have a choice to place the child with a foster family or with one of the two parents if one of the two is capable and safe to be with, right?
Correct. Or a relative.
And what happens 3 weeks later at the next hearing? What is that hearing called?
It's called the jurisdiction and disposition hearing. That is where the court is answering the question of jurisdiction, which is this court the appropriate court to make orders?
And if it's not, then it will be family court, correct?
No, if it's not, the case should just be dismissed at that point. The question at disposition becomes, what are we doing about a juvenile dependency case? And there are 3 potential outcomes. Either it's going to be a family maintenance case, which means the child or children are placed with one or both of the parents. If the child is not placed with either parent, but is placed with a relative or a foster parent, then the parents may be offered something called family reunification services, which would be essentially the same types of services as family maintenance services. Reunification just describes that the child's out of the home. And these are, again, services designed to remedy the reason for why the child came into court. The third outcome is bypass, and that's the outcome you want to avoid. And that means that the court system has determined that it is not in the child's best interest for reunification services to be offered to the parents. Those are most likely drug cases where addiction has been so prevalent during the parent's life that they've lost multiple children throughout their addiction.
What's the last hearing?
The last hearing, well, it depends, right? The last hearing could be a family maintenance hearing, right? Where the court is saying, child with one parent, they've had at least this 6 months of services, seems to be going well. We can close the case now with what are called exit orders or family law. The other type of sort of final hearing is called the 2-6 hearing. And that's a hearing to determine a different permanent plan. That's a hearing where reunification efforts have been unsuccessful or were bypassed entirely, and the court is looking at what is the best permanent plan for this child's future.
Okay, let's get gritty. Audience Q&A questions. You ready?
Yes.
Okay, we have our first question from the audience. Ooh. I'm 11 months sober, but my ex keeps using my past addiction to block custody. What can I do?
This is a great question. Like, that's a huge accomplishment, and that should be celebrated. And so there should be people involved in your life that are supportive of that. And so a good start would be finding your supports, right? And letting them know, hey, this is something that I'm struggling with right now. The next should be that if you aren't working a program, whether it's like a 12-step program in NA or AA or Smart Recovery, or some faith-based recovery service, if you're not working some kind of program, you should be working a program. The reason is the programs are done in languages that courts are familiar with. A lot of the judges in this county especially receive trainings on what these programs are, how they work, what kind of sort of benchmarks exist that make them effective. And so there's a bit like a secret language to recovery. And if you're working a program, you can speak that language and the judges will understand what you're saying, right? If you have a sponsor, if you're working steps, do you go to meetings? Are you somebody who has a service commitment at those meetings, right? Do you have a higher power, right? These are all somewhat faith-based types of programs. And the idea behind it is that recovery is not abstinence, right? So if you are 11 months sober, right, that means that you haven't consumed anything in 11 months, but are you actively working on your recovery or are you just abstinent? Because if you're actively working recovery, then you've got mountains of evidence to present to the court about why this person is manipulating your past using. The other thing to understand is that early recovery is technically defined as 3 to 5 years, right? So your first 3 to 5 years of sobriety, you're still going to kind of be under a microscope. Everyone's got a little bit of a different story about what helped them become sober. And it gets better with time.
We are going to wrap up with Nicholas's advice to parents who are facing system involvement. What advice would you give?
Understand that what you say can be against you. Understand that the people that are involved are primarily concerned about one thing, and that is your child's safety. And if you don't have the ability to articulate a very clear plan, how to keep your child safe. And I wouldn't talk about it with anybody until you're ready to have that.
Thank you. And again, Nick is an extremely talented attorney. He's with our firm, knows all the in and outs of juvenile court system. So if anybody needs advice, feel free to reach out to him.
Yeah. Thank you.
Thank you for having me.
Don't miss next week where we sit down with the TikTok lawyer himself, Ryan Steigart, and look at the intersection of social media and legal rights.